and we've got a really nice crowd in. We're actually about to hit our full capacity of 100 people. We can't have anyone more. So we're on 98, 99, and we're full, which is fantastic. It's nice that you're in, and it's nice, yeah, that we've got a good crowd. So for those of you who don't know me, my name is John Giles. I'm the managing attorney at Michalsons, and essentially I help large organizations to comply with complex laws in a practical way. And that's the essence of what I do, and the GDPR is definitely one of those laws. It's a complex law, and what we've noticed is that there are lots of large organizations in South Africa who think that the GDPR does not impact them at all. They don't think they need to comply with it, and to a large extent they're ignoring it. So we thought we'd do this webinar to raise awareness around GDPR and to empower people with knowledge about the subject. A little bit more about me for those of you who don't know me. We've been helping clients with the GDPR for about 2 years now, since about May 2016 when the law was enacted. And we've been advising various different clients. We are also part of the Lexing network, which is an international network of IT and data protection lawyers. And this year actually, I attended a conference in Milano in Italy where we discussed the GDPR in some length, and that was fascinating to spend some time with people who are in Europe, and people like Dr. Bottarelli, who is the European Commission's head of data protection. So I've learned a lot through that process, and I've also been doing some workshops on GDPR, and I've bought a lot of books on GDPR. I've been reading these furiously over the last few days again. It really is an interesting law that's tricky, but what I've tried to do is be your eyes and ears. So I've tried to read everything from the perspective of a large South African organization and try to distill that knowledge into a session like today to try and save you time and really give you what you need to know. So I'm hoping you'll find a lot of value today, and I'm also hoping that there'll be quite a few questions and quite a lot of discussion. So let me switch off my camera, and instead of that, I'm going to start sharing my screen with you. But before we do that, I just want to have a look if there are any questions or if anyone's struggling with anything. No, we look good. I've also got a co-organizer on the line with me who would be able to help if there are any technical problems, but we seem to be doing well. All right, great. So let's dive in here. I will stop at different opportunities to check for questions and to give anyone an opportunity if they'd like to talk about anything or ask anything in particular. But if we start here with hello, we've spoken a bit about me, maybe just quickly to show you here. This is a picture of the presenters at the last GDPR conference in Milan. I'm standing over there, peeking there, but there's some quite amazing people in this picture. That's Dr. Bottarelli over there. Yeah, it was a very interesting conference. All right. The other thing about me, just to show you this picture, is that I really believe in trying to explain things simply, and I'm really going to try and do that today because we only have about 45 minutes and some question time, which we can stick around for at the end. But time is limited, and I know your time is valuable, so we are going to go quite fast and really deal with the key issues. Most of you know Michalsons. Really just to say that, as you know, we believe that the law should be accessible, empowering, and helpful, and that's really a large part of the reason why we're doing a webinar like this, is to make the GDPR more accessible, because it's a tricky law. We'll see today there are various issues that really are hard, and I think partly it's because the GDPR was translated from another language into English, so it's not terminology that we're used to. And it makes it quite hard to interpret it, quite hard to understand what it's saying. The program today, yeah, we're about 45 minutes, and as I said, I'll break for questions and answers at a few different points. We can also, at the end, we can have multiple questions. In terms of handouts for today, we will be emailing you probably tomorrow to everybody who's attended today. We'll email you with a link to a recording of this webinar. And maybe some follow-up information depending on what happens and how the discussion goes. All right, then talking a little bit about you, this webinar, as the title said, is very much for large South African organizations. It's not meant for small and medium-sized businesses. It's for large organizations. And I'd like to, I have a good idea of who's on the webinar, but I'd like to just run two quick, well, I think it's one quick poll just to get a better idea of who's with us today and whether or not you currently think that you must comply with the GDPR. So let's run a quick poll. All right, let's launch this poll. Must my organization comply with the GDPR? And select one of the three. If you wouldn't mind selecting one, let's get a view of how many of you on the line currently think that your organization must or mustn't comply with the GDPR. Voting's going well. We're at about 65%. Yeah, we're shooting along. Last few people to vote. All right, that's almost everybody's voted, so let's close that poll and we share the results. And I'm quite surprised that it's 59% of people say yes, they must comply with it, 4% say no, and 37% say I'm not sure. So that's interesting. I think we'll run this poll again at the end of today, and I'm particularly interested to see if that percentage of 4% changes, and also if the percentage of 37% changes, because I think that 37 is really the key number. All right, let me just check if there are any particular questions. Yes, Jean, we will be sending you a recording of today. Joanna, sorry if you can't, well, you won't be able to hear me saying sorry, but shame Joanna seems to have a problem with sound. I think everybody else is fine, so it must be something particular on her side. All right, so thanks for that poll. That was very interesting. All right, so this is our presentation as a whole, and I'm just going to be diving into a few key aspects of it today. Many of you will be familiar with our data protection tree, which symbolizes what action you need to take to comply with data protection law. But I'm going to go into this introductory section here, and I'm just going to go to this globe over here and talk a little bit about the global view, and very much talk about the GDPR, which stands for the General Data Protection Regulation. I've been very consistent over the years in saying that it's very important to have a global view with data protection, and you shouldn't focus in on any one particular data protection law. But I think the one exception here is very much the GDPR. If we look in here and zoom into here, is GDPR is definitely different to others. It is the gold standard of data protection laws, and it is going to be the most important law in the world when it comes to data protection. So you've got to have a really good grasp of what it's about, but it still, I think, is to keep that global view and be considering all the laws that you need to comply with. And very quickly to show you the process we recommend is you should first understand which countries you're established in. To which countries do you offer goods and services to the people who live in them? In which countries do you monitor the behavior of people? And then also, where do you actually process personal information are questions that you should be asking relating to all countries. And then based on that, you should then be asking, well, what laws do those countries have, and identifying all the data protection laws that your organization must comply with. And unfortunately, the answer is often many. There could be 30, there could be 40, obviously depending on the answers to those questions. There are lots of data protection laws. This diagram, the blue countries have data protection laws, the red are in the process of getting, and white currently have no initiatives or no information about it. I'm not going to go into that in more detail because I really want to focus in on the GDPR, which is one of these laws that that is very, very important. And the two questions that I want to ask at the beginning, because today is about understanding how it impacts you, but before we get onto that, you have to ask, who does it apply to? Must I comply with this law? And we've seen there about 37% of people on the call today who aren't sure, and you need to be sure about this. So I'd like to delve into this in a bit of detail, and the way to work out who the GDPR applies to and who must comply with it is to ask some questions. And if you answer yes to any of the following questions, then the GDPR does apply to you. So let's get going with the first question, which is, are we established in the Union, in the EU, or in a place where member state law applies? A good example here is Reunion Island. It effectively is a French territory, and French law applies, and therefore member state law applies. And it's if you're in Reunion, then you have to comply with the GDPR. But then the question is, are we established in the European Union? Which is quite tricky terminology. Us as South Africans, we're used to the terminology of where are you domiciled? A good old Roman Dutch law term. But really the question is, do we have the effective and real exercise of activity through stable arrangements in the Union? And those are the particular words that are used. And this raises an important point, is that when you're reading the GDPR, you must look at both the articles and also the preamble, the whereases, which are about 140 of them or something, and they go on for a very long time. But they're very useful in explaining and giving you the context around certain of the articles, and this is one of them. So the question is, do we have the effective and real exercise of activity through stable arrangements? Now, there's some case law on this, but some of the pointers that are related to it is that it can be any legal form, like a branch office or a subsidiary with legal personality, but it can be something without legal personality. So even if you don't have a registered company or legal entity in the European Union, you can still be established in the Union. Even if you have minimal activity, it's been held that you do have, or you are established in the Union. And if you're established in the Union, then it doesn't matter where the processing takes place, GDPR will apply. So for many of you, it'll be quite easy here. I think for a large percentage of you, the answer is yes, we're established in the Union, and there's no doubt. For those of you who are a little bit uncertain, I think it's, we'll talk a bit more about this just now, but do you have stable arrangements, which mean you have activities? Do you process personal information in the European Union? Or do you have the means to process it? Right, so that's the first one. The next question is, do we offer goods or services to people in the EU? So if the answer is yes, then GDPR applies. Let's also ask some sub-questions here. Do you offer free goods or services? And if the answer is yes, GDPR applies. Now, many people argue, well, no, we do, but it's for free, so therefore the GDPR doesn't apply, and it's explicitly stated that it doesn't matter if there's payment or not. Any goods or services do apply. Then the next one is, do you envisage offering goods or services to people? there, so it's not even that you do, but do you envisage it? And good indicators of that are things like, do you use a language used in the EU? Can people order goods or services in an EU currency? Do you mention customers or users in the EU as people who are your customers? You know, often, for example, on a website, it would say, um, we're a law firm, and we're a global law firm that services clients anywhere in the world. And we could actually use Michalsons here as an example. We very much do provide goods or services to people in the European Union, so GDPR does apply to us. But what they're also quite clear on saying is that just because you've got a website that is accessible, or you've got an email address that somebody could email you from the EU, doesn't mean that you're providing goods or services. It has to be a bit more than that. It's something you've actually got to envisage it and be targeting Europeans, as it were. And sort of factors and questions that are asked here then is, do you pay search engines to advertise to people in the EU? Is your activity of an international nature? Do you mention telephone numbers with an international dialing code? Do you have domains from a top-level domain? So Michalsons is a good example. We have a telephone number that's only for people dialing from South Africa, but we have another number which starts with +27, indicating that anyone in the world could phone that number. And so we clearly are anticipating and envisaging people from other parts of the world and contacting us. We also use the domain michalsons.com and not .coza. .coza does work, but .com is our primary domain, which indicates that we are envisaging having or providing goods or services to people outside of South Africa. So those are the questions and the thought process you need to go through, and I think this is where many people start thinking, whoops, I didn't think I had to comply, but maybe I do. An important thing to mention to here is you're offering or envisaging providing goods or services to people in the EU. So if it's a citizen of France who's living in South Africa, that doesn't count. It's got to be a citizen of France who is resident and is in the Union. It's when they're there. And that catches a lot of people, because people say, well, you know, I can't be sure, but in our client base of 3,000 people, I'm sure there are a few European citizens. Because they're living in South Africa, and they don't count. If they're living in South Africa, it's not relevant. It's only if they're there. The next question is, do we monitor the behavior of people in the EU? Now, the question is, does their behavior take place in the EU? So again, the person must be in the EU, and you're monitoring their behavior in the EU. But good examples here, do you track people on the internet? And if you are, the answer is yes, GDPR then applies. Do you profile people in the EU to make decisions about them? Again, yes, it applies. Do you profile people in the EU to analyze or predict their personal preferences, behaviors, or attitudes? So any of those, you're responding yes, then you're going to have to comply. The next one is, are we a processor for a controller who must comply? Now remember that in South Africa, a processor is called an operator and a controller is called a responsible party. But it's basically, the question is, so you might have got to this point and said, oh no, this is great. We're not established in the EU. We don't provide goods or services to people in the EU, so data subjects in the EU. We don't monitor their behavior. It looks like I'm off the hook here. But if you process personal information for a controller or for an organization in the EU, then you are going to have to comply, because the controller is obliged by the GDPR to contractually bind you and make you comply. So it's an indirect impact, but it is going to impact you. And we've seen this with many organizations in South Africa who don't have to comply, but then their largest customer says to them, you must comply. And that's the end of the story. They have to comply. So that's going to catch a lot of people as well. Then the next question, and this is for me really the interesting one, do you have a processor in the Union or in the EU? And this gets back to that wording of do we have the effective and real exercise of activity through stable arrangements? So if you have a long-term contract with somebody who processes personal information for you in the European Union, I think there's a really good argument that that's a stable arrangement, and there is activity, in other words, activity to process personal information. It's very interesting as well, the word activity coming up here. Many of you will know that we've for years have spoken about how you should map your activities, and this ties in very much with that thinking. So yeah, that's the question. So the problem would be here is that you're a South African organization, you've answered no to all the previous questions, but you use somebody in the EU, like for example, Microsoft in Ireland, to process some of your personal information. They now a processor for you, and the question then is, do you have a stable arrangement, which often would be, that gives you the effective and real exercise of activity in that area? So this is an interesting one, and I haven't been able to find the answers to it, but there are conflicting views in the books, but certainly there is a strong argument that if you do have a processor there, then it does apply. All right, let me just have a break here and let me see if we have any questions. Okay, just a sec. I'm going to come back to some of those questions. I just want to zoom out here. So really, that was finishing who the GDPR applies to. So anyone who answered yes to that, GDPR applies to you. So let's look at a few questions that we've got here. I'm afraid you won't receive the slideshow, Mohammed. It's just a recording of today. But I mean, the recording is effectively everything that's happened today. Shamak, some people are struggling with the audio. I think that that's probably on your side rather than my side. Yeah. In terms of audio, I'm not sure what to suggest. I'll speak loudly and clearly. All right, then the question is, what is a processor called in South Africa? So they're called an operator. Great, Mohammed, I'm glad you're enjoying it. What about our association with the Commonwealth? Yeah, that's an interesting question, Johan. I don't think that, I mean, I suppose it comes in under who must comply, and the question would be, it's or a place where member state law applies, but it wouldn't in terms of common law, sorry, the Commonwealth. So I think that doesn't have an impact on us. Audio seems fine on many people's side. Ian, would Salesforce.com be classified as a processor? And if you use them, would you need to comply? Yes, they definitely would be a processor. And yeah, Salesforce is interesting. They have data centers in many different parts of the world. I think Salesforce has actually just announced a partnership with Google Cloud, if I'm not mistaken. And Google's obviously in many different jurisdictions. So I think this is one we're going to have to really watch because, to be honest, as I said, I haven't been able to find the answer. But it really is one that could catch many South African organizations who have been thinking, oh, no, we're fine. We don't have to comply. This one could catch many of us. Does processing data of SA citizens who happen to be expats in the EU introduce GDPR liability? No, you wouldn't then need to comply. It's only if they are in the EU and resident in the EU. There are a few other people struggling with audio. When you process EU citizen data, would the GDPR apply? Yes, so if you're processing, the key is where are they? They must be in the union is the key point. But that's the idea. It's GDPR is trying to protect the privacy of EU citizens in the EU. Yeah, Gene's got a good point. Is saying, wouldn't it be a good idea to just comply in case? And I think that is a good point. We'll talk a little bit more about that just now. I'll got some slides to talk about that. If people visit your web page and they are tracked, but we don't offer a service or product in the EU, if we now need to comply with GDPR, what is the risk? Yeah, so that is, even if you're not providing goods or services, but you're tracking them, then you do need to comply with it. And we'll get into now, if you do need to comply, what that means for you, and what the implications are and what the impact will be on you. Jana, great. I'm glad you're enjoying it. Yes, yeah, compliance definitely will help you with other forms of compliance. We'll talk about the relationship with POPIA just now. Where an EU company has bought shares in a South African company, would we need to comply? Sure, that's an interesting question. So you've got an EU company. Yeah, so I mean, the EU company is definitely going to have to comply. And because they've got shares in a South African company, it doesn't matter where the processing happens. So if they are established in the European Union and then process anywhere in the world, the GDPR is going to apply to them. And I'm sure that they will require all their companies in which they own shares to comply. So I think there will be a ripple down effect. What about supply relationships with EU vendors? Yeah, I mean, that is, okay, so that's where you've got an EU vendor. So you've got a processor in the European Union who is providing a service to South Africa. I think that's suppliers with EU vendors. Yeah, so that's what we've been talking about now. I think we've covered that one. Oh, there are a lot of questions here. I'm trying to go through them fast without and picking out the ones that I think we haven't dealt with. Yeah, the legal agreements with organizations in the EU are certainly going to be affected. The GDPR has a big impact, not only one level down between a controller and a processor, but there are also obligations on a processor to contractually bind a sub-processor. So we've been seeing this already and we'll continue to see significant impact on all agreements. Yeah, so Shane asked, what if you process personal data for companies based in the EU? Yeah, then you are their processor and they're probably going to require you to comply contractually. So Mohammed asks, are there any implications specifically for financial institutions? So it's an interesting thought, is that the GDPR applies to all organizations in all sectors. And financial institutions are particularly highly impacted by data protection laws, but the principles apply to everyone. So Johan says, so basically, if you have forms on your website that can be accessed and completed by people in Europe, you will have to comply. No, not necessarily. If the law actually mentions this, if someone can access your website from the EU, it doesn't automatically mean that you do. It's if you are envisaging and if you're actually targeting them, and that's where they start looking at those factors of do you use German, for example, as a language that people can choose to input the form, then certainly you are targeting them. All right, next question is, if your mail server or other files are hosted in the EU, but you only deal with RSA customers, does the act still apply to your company? Yeah, that's the last one we looked at, which is a concern for me, is that you've effectively then got a processor in that country, and the question is do you have the effective and real exercise of activity through arrangements, and so I think there's a good chance that that could be the case. We track people on our website, but we do not track any personal information, only location. Would GDPR still apply to us? Definitely. You know, the next that question, which is really relevant, is, are you processing personal data? And if it's anonymized and you don't know who it is, then it's not personal data, and then the law doesn't apply. But not because of a territorial scope of the law, but because of it not being personal information. Right, Michael asks, if you have a subsidiary in the EU that has a leak in the EU, not in South Africa at holding company, would the penalty of worldwide turnover be applied at an SA holding company level only? Sure, that's an interesting one. Yeah, so this actually raises a very good point, is that let's say you've got 10 entities in the group. If the if the South African holding company doesn't process it, has answered no to all of those questions, but the European entity has answered yes, I think there is an argument to say that GDPR only applies to the entity in Europe and not the South African entity, and therefore it's only looking at the European turnover to determine the fine. And then Stefan saying, will the use of global travel inventory system when you're booking as a travel agent apply even if only dealing with RSA customers? Yeah, that's a good example. The travel industry, there is a case that was specifically dealing with the travel industry, and because of the international nature of the travel industry, there is a good chance that GDPR is going to apply. All right, let's pause there for a minute and let's run another poll, which is very similar to the last one we did, but is asking, must my organization comply with the GDPR? So it's exactly the same, but let's see if those percentages have changed at all, and based on those questions. Just a few more people need to vote. We're almost there. Maybe some people are now trying to make up their mind. There are some tricky things there, and that's what I mean about things look simple, but then you start digging and trying to interpret certain different words, and it starts becoming a little bit harder. All right, virtually everyone has voted, so let's share the results. So we now 71% say yes, up from 59%. 16% of people say no, which is interesting, and 13 say not sure. So it looks like we have managed to help many of the people who were not sure into deciding yes or no, and I'm interested that there's 16% who say no, which is fantastic. I've got some really good news for you, and I'll be covering that shortly. All right, so let's go back to the presentation. All right, so we've decided, and I hope you like this. I've got who me, because picture somebody and say, do you know the GDPR applies to you? And they go, what? Who, me? So that's what I was trying to convey with this slide. So we've gone through the who and that's looking at an organizational level. So which organizations have to comply with the GDPR? And then if we go onto the me bit, the question here is it me or is it someone else in our organization who is responsible? So let's look at a few scenarios here. Let's say you've got a large organization in South Africa, but only South Africa. You've got 5 companies, you listed, you're in South Africa, and you're only in South Africa. The GDPR might apply to you because you might be providing goods or services to people in the EU, and so you need to comply with GDPR, and there's a good chance that if you're the person responsible for data protection for your organization, it's going to be you're the one who has to comply. But then let's look at a true multinational that's in 36 different jurisdictions and who has to comply with 30 different data protection laws. Yes, the GDPR applies, and POPIA applies, and in those scenarios, often it is not the person in South Africa who must comply. Often it is the person in somewhere else in the world who must comply. And often this would be the head of compliance. There might be a global privacy program manager. There might be a data protection officer. There are often many people that that are responsible for it. And I've got some good news for those people too, because if it is somebody else, it significantly lowers your role. And really, so if it's not you, then it's not really your responsibility. And what I would suggest you do, and we have some questions over here. I'm going to skip across to here, is you should find out who that person is if you don't already know who they are, and then make some inquiries. Ask them how they are dealing with the GDPR. What are they doing? What actions are they taking? Also then ask them how they're going to deal with specific local laws in each country. So what approach are they taking from a global perspective? Are they viewing it from a global perspective, and have they taken into consideration the extra compliance requirement in South Africa when deciding what to do on a global level? Also then ask them, what information can I give you to help you? Because really your role then is to help them understand how South Africa is different, give them guidance and assistance, and then at a point in time, once they've done what they need to do globally, you might need to localize certain documents or compliance efforts for South Africa. But it's GDPR first and then South Africa, and your role is much less and quite limited. So in that respect, what we've developed there is we've created a document, which, let's skip across to that there, which is called our GDPR POPIA comparison report. And the purpose of this document is to then identify what the difference is and the extra compliance requirement is under POPIA. It's that slither there. We'll talk about this in a bit more detail just now. But yeah, that's the idea, is that you're able to then tell the person who's responsible for global and GDPR compliance what the extra compliance requirement is. All right, so let's go back to here and back to GDPR. So we're saying, so for those of you, so for the 16% who said the GDPR does not apply, my recommendation for you is to go on holiday. Don't leave just yet. You can listen to the rest of this webinar, but really you can go on holiday. The GDPR then does not apply. And what you do need to comply with then is POPIA. But I must say POPIA is taking a very long time. And there is a good chance that the commencement date will only be late next year. We really don't know, and the information regulator is not giving us clear guidance. But there's a good chance. I mean, well, there's a chance that it could be at the end of next year, even the beginning of 2019, and then you've got a 12-month grace period. So we're probably looking at anything from 18 to 36 months until the deadline for POPIA. So if you're in that boat, there is lots of time, and I wouldn't stress, and I would enjoy December and January and have a really good time. What you could do, though, is you've got to keep a watchful eye on the EU, because the GDPR is going to have an indirect impact on POPIA. And so you really should keep an eye on developments with GDPR, but it's not really your problem. You also will probably be in a better position to comply with POPIA next year, particularly after the GDPR deadline, because the rest of Europe, well, everyone else who's complying with GDPR would have done a lot of the really hard work already, which will probably make it a lot easier for you to comply. All right, so we've spoken about those people, and we've spoken about that. So what I wanted to do here as well is talk a little bit about the overlap between different laws. A few people asked me these questions before today, and I think let's finish this and then we'll go back to some questions. So for those of you who have to comply with many different laws, this diagram is hopefully quite helpful in that each circle represents a data protection law in a particular country. And if you were to draw each one on a piece of paper, what we find is that there's an 80% commonality between the different data protection laws. And when we talk about adopting a global view, we suggest that you do this exercise and establish what that 80% is, and then focus on that 80%. Makes life a lot easier. Another way of showing you this is by showing you this slide. So what we've done here is try to represent a comparison of the GDPR on the left and POPIA on the right. GDPR is the blue circle, POPIA is the green circle. You draw a circle for each one of those, and you see that it's 80% the same. There's a lot that's common. There's a little bit that's different in the GDPR, and there's things that are different in POPIA. And it's important to know what that extra compliance requirement is on each of them. But if we look at this table, it gives you quite a good indicator of the comparison. So we've got GDPR on the right, POPIA on the left. And really it's about terminology to begin with, but it's the same thing to a large extent. Account numbers is something that's specific in South Africa, not in GDPR. We have children as 18 years, they're younger in the EU. They focus also on genetic data. We have juristic persons as data subjects, whereas they don't. And they focus on data portability as a key thing, whereas we don't in South Africa. We talk of risk assessments, they talk about impact assessments, but they're very similar things. So you can see there's a lot of similarity. This is just a quick diagram to show you some of the differences, but that report that I showed you earlier is really this slither over here, this green slither. It's setting out what's the extra compliance requirement in POPIA. Because what a lot of organizations are doing is they have to comply with POPIA, GDPR, Australian law, Canadian law, and so on and so on and so on. And so what they're doing is they're saying, let's do GDPR first, focus on that, and then we'll look at the extra compliance requirement in other jurisdictions like South Africa, and that's where this report becomes very useful. All right, so let's pause there for a sec, and let's have a look at some questions. All right, so Malcolm asks, a lot of references are for personal data. Does the GDPR largely relate to B2C relationships, or does it also relate to B2B? Yeah, so GDPR is B2C, POPIA is B2C and B2B. Michael asks, when do you require a full-time information officer in the EU? What thresholds apply? Yeah, that's a significant question with quite a lot to go in. So in the EU is called a data protection officer. South Africa is called an information officer. And yeah, there are many organizations that need a data protection officer. We've actually got some guides on DPOs, and there's some information on our website about it. I don't want to go into too much detail now, but many people do need them. The other thing that's scary is that if you are an organization that is not established in the EU, but you must comply with the GDPR, you have to appoint a representative in the EU, essentially someone who the regulator can get hold of. So that's very related to that issue. So at the beginning, I said that this applies to large organizations. What is the threshold? So when I say it's large organizations, that's because we focus on helping large organizations. But the GDPR really applies to everyone. There are very few exclusions. There are some things that SMEs are exempt from, but the general statement is that it applies to everybody. So what legislation covers juristic persons in the EU? So there really isn't any. South Africa is the only country in the world that has protected the privacy rights of juristic persons. We're also one of the few countries that actually recognizes artificial persons to have personality rights. Virtually nobody else does. So Peter asks, where and when will we be able to get a copy of the comparison document? That's something we'll talk about just now, but I'm afraid that document is a paid document. The fee for it is about 2,500 Rand. We'll chat about it a bit more just now, but it is a document that we provide to clients, but it is paid, I'm afraid. All right, let's get back to a poll, and I'd like to ask a question here. Who is responsible for ensuring we comply with the GDPR? And I'm interested to get a quick snap poll here. Is it you? Is it somebody else? Or are you not sure who it is? Our votings, we're past the 50% mark. We're almost there. All right, we're almost done. So let's close that poll and share the results. Right, so we 28% is me, so it's you, and then 47% is somebody else. That's very interesting. And then 24 is not sure. So if you're not sure, a good option is to try and start asking questions and start trying to identify who else within your organization globally could be responsible, and meeting with them. We found with many clients when we talk about this and encourage them to do so, they often find global person, and that global person is often very organized and is well on their way to ensuring global data protection compliance, and it's often a very good conversation. Often they're not as aware of South African data protection law as I would have expected, but it's always a worthwhile exercise. All right. So another question here quickly to clarify, if you do not deal with consumers, only B2B relationships in the EU, then GDPR will not apply. Yeah, so it's in a context of of the data subjects being legal entities. So B2B, then it won't apply. But not if you are a processor for a controller. But in the relationship of controller data subject, then it would not apply. All right, so let's go back to our presentation. All right, so we've chatted about that. So a few other things to show you now. So now we're looking at what the impact is of GDPR, and I'm going to try and give you a very quick overview because we don't have a lot of time. Just pick out a few key things that I think are important. The first being relating to the timeline. The GDPR, the deadline is the 24th of May 2018, and that is a fixed hard deadline. And so there really, if GDPR applies to you, there is no time to lose. These blue lines represent the POPIA grace period, which this date, we don't know the start date. It could be late next year. And then you've got a 12-month grace period. So POPIA could be 2 years away. GDPR is 24 May next year. That's the deadline. That's the end of the grace period. And so there really is no time to lose if to comply with that law. Then to quickly give you an example here, this is a slide setting out the rights of data subjects. They have rights to information, to participate in how you process their data. They have a right to data portability, or for you to port their data, and also a right for no automated decisions. Then controllers have certain obligations, and very quickly there, just to pick out a few, it's to implement measures to secure it, to control your processes, keep records about how you process. A controller must cooperate with authorities, secure personal data, conduct assessments, consult with authorities, appoint a DPO, and comply with codes. We've also got here is a list of processes as well. But really the the point being here is that the impact of GDPR is significant, and there really is a lot to do. We're not going to be able to get through it today, but there are a lot of things that you are going to need to comply with. There are many different compliance requirements that are going to require your attention. The risks are quite significant. This slide illustrates those risks to you, and particularly so in the GDPR there are no criminal offences, so nobody is going to jail. Fantastic news, no one's going to jail, but the fines have been increased dramatically, and they are really significant, up to 4% of global annual turnover. So it makes the 10 million rand under POPIA look like child's play. The fines are huge, but Dr. Bottarelli has said that he is not recommending that regulators and authorities come out guns blazing in May, and that they won't be dishing out fines provided they can see that people have a plan, they are proactively taking steps towards compliance, and they may be making mistakes, but at least they're trying. That's literally his words, which was I found very interesting and a very good approach. It's still reputational damage is the biggie. We're seeing this in South Africa. Even though POPIA is not enforced, the reputational damage aspect of it is really the driver for complying with any data protection law. We're also anticipating, and so are many of the members of the Lexing network, there being significant litigation, and to a large extent that being the driver of compliance in the EU come 25th of May. So that is by many is seen as the biggest threat or risk after losing customers. And so our process is that you've got to learn or raise your awareness around GDPR, then plan what actions you're going to be taking for GDPR, and then actually implementing those actions, which here are grouped by different departments, and sets out what they need to do. And then at the end you review or audit what you set out to achieve, and that's the final step. So let's pause for a minute to just see if there are any questions. Not at the moment. So in summary of where we're up to is, the question is, must you comply or not? No. Go on holiday? Yes, you must comply. Then you must ask yourself, who's responsible? Is it me or someone else? If it's someone else, identify that person, assist them, help them understand the difference. If it's me, you need to understand that impact. And really that's what, the impact is significant. And the question then is, what's next? What are the next steps you can take? And what does it mean for you? And the one thing I'm going to show you here is that we've developed an assessment where we can assess the impact on you. And if you go to this page over here, you can access this assessment. And let me see if I can actually, I think I can pop the link into the box there. So you can have a look at the page, and there you can access the assessment there. We do that assessment for free. There's no charge, and it involves a questionnaire, and then we set up a call to discuss your particular organization and answer particular questions. And it's quite a useful way of doing a high-level impact assessment of the GDPR on your organization. So that's a step that you could take next. And then the other next steps, there are essentially 3 different options that you can take in our view. So now this is particularly for people who must comply with the GDPR and for people who are responsible. So the first is you can comply yourself is the one option. And here organizations attend workshops, they find books, and then really work out what to do themselves. It's a significant effort. And I think for most of you with large organizations, it's a really tough job. You need someone assisting you. You need expert assistance and guidance. So what we're doing is we're running workshops on the GDPR. The next one is on the 23rd of November, and it's a full-day workshop in Johannesburg. And we'll go into a lot more detail than what we've been discussing today. but really getting into a lot of the important things, really with the intention of empowering you with the information you need. If you attend that, you get the presentation, you get the comparison report that we looked at earlier. If you don't want to attend the workshop but want the report, it's 2,667 Rand for that report. I can actually show you here. This page on our website over here, and I'll send you the link there, gives you more information about that, and you can read that there. So the the workshop, you also get a handout on the key insights around data protection, and there's also a 45-minute video that is included as part of that workshop. You get all your questions answered, and we look at the practical application. So we think the value is around 8,000 Rand, but the price per delegate is 4,000, around 4,500, including VAT. So that workshop, it's reasonably full already. If you do want to attend, I suggest booking quite soon, because we will have a limit on the number of people who can attend that as well. The second option is that we comply with you, and in this regard, we have our Michalsons Data Protection Compliance Program, and there's a huge amount of information in here. We've been working very hard at this. It's a 12-month program, and we're 6 months into the program already, and it includes everything that's in the workshop, and then guidance in a structured program format. It includes the laws and links to other laws, and then various tools to fast-track your efforts in the sense of templates, in the context of reports, extra guides. There are also many events to participate in. We have a webinar that's weekly that's part of the program. And also, if you're in the program, you're entitled to attend one of those workshops. There are lots of recordings that are in the members area for the program. And there's a community or forum where people can discuss issues, and also personal support. So included in the program is up to 4,000 Rand a month's worth of personal support, which involves a one-on-one call to discuss your particular issues. So the value here is huge, and at the moment we're offering that if you join before the 23rd of November, there's 6 months to go on the current program, and it's about just under 10,000 Rand a month. So over 6 months, that's 60,000 Rand is the investment. And it's a really good time to be joining. And if you have to comply with the GDPR, there's really no time to lose. You have to move on it fast. And if you join before 23rd November, you can attend the workshop and then participate in the program for the remainder of our program. So that's the program, and we also offer a guarantee here, and it's also paid on a monthly basis. So if you want to end at any time, you're not tied in for the full time period. If you don't think you're getting value at any time, you can simply terminate your membership and leave the program. The last option is we comply for you, and here we have many different solutions, many different things we do for people. One example is doing a gap analysis. And here we can give you a fixed price quote to assist you with any aspect that you require help with. And I think a good way of comparing these three examples is, if you want to comply yourself and attend the workshop, we'll talk about privacy policies and give you some insights about them. And then you would go and create your own privacy policy. When we comply with you as part of the program, we give you a privacy policy template, and we have a webinar specifically talking about how to draft your own one and working through all the steps, explaining what's really important to be doing. And then when we comply for you, we would actually do that privacy policy for you. So you instruct us, we draft one for you and provide it to you. And obviously the we comply for you is the most expensive, with the you comply yourself being the cheapest, and the program being in the middle. So those are what we see as the next steps and options. And yeah, so let's have a pause now and let's have a look and see if we've got any questions. So what should we be concerned about in terms of automated decisions? Whew, that's a long answer. Essentially, the law doesn't want computers making decisions about people, and so there are restrictions around that scenario, and it definitely ties in with artificial intelligence and robo-advisors, but that's quite a long answer to do. So Jacqueline asks, how do we start the process? In the email that we send you tomorrow will be links to different things, but if you'd like to join the program, you can apply on this page over here. This is the program website, and from there you'll be able to apply by clicking on that red button, and there's a lot more information about it, and that would then kick off the process of applying to the program. Malcolm, it's a pleasure. I'm glad you found it useful. Ian asks, is there any specific that we need to be concerned about in terms of the legal basis for processing personal data? Yeah, I mean, there's a huge amount that comes into data protection compliance when it comes to processing personal data. We're not going to have time to talk about that today, but there certainly are a lot of steps to take. So Yaku asks, if we offer a backup archive service, would we need to be able to delete info from the backup if asked for erasure? Yeah, that's a fascinating question. It's also, it's a rather long answer. Yeah, I think there is a way of arguing that you don't need to delete specific info, but we need to engage Yaku on that and talk through that in quite a lot of detail. Catherine asks, or just says, thank you very much. And Heather asks, should we stop following people in the EU on social media? Sure, that's a good question, because I guess that could be a factor of saying, well, are you envisaging targeting Europeans with goods or services, or are you monitoring them by looking at social media? And I guess there's an argument that you are. Yeah, so that's a good point. Clifford, it's a pleasure. I'm glad you got some clarity. And Johanna, it's a pleasure. I'm glad you enjoyed that. So we're pretty much out of time. Yeah, I think the last question that's come through is, to be ready by May 2018, is there a step-by-step process to be followed? And that's essentially what we try to do with the program, because there's a lot to digest and you can't really do it all in one go. So we broke it down into modules, and the modules then cover roughly a 12-month period. And the idea is to tackle each module, each bit all on their own, and tackle them over a period of time. And that's why we came up with the program, and that's what we've been doing in the program, and it works really well. You have to follow a step-by-step process, and we very much believe that, as Dr. Bottarelli said, is that if you can demonstrate you're working towards compliance, you're following a process, and you're trying to get there, it'll stand you in good stead in arguing that you're okay. Israel, it's a pleasure. Phyllis, pleasure, no problem. Suzanne, I'm glad you enjoyed it. And then Jacqueline asked, would you run this program on our behalf? So I think that's a scenario of saying, well, would we do it for you? And certainly we can do it for you. I think the key there is to scope what you want our assistance with, and we then will be able to provide you with quotes and a proposal about how we can help. I think looking through that page there will help you significantly, particularly about the different options, and here where it talks about we comply for you, and looking at our data protection solutions there will help you in how we can help, and then getting to a proposal there. Pleasure, Peter. I'm glad you found it insightful. All right. Yeah, so that's essentially what I wanted to cover today. Any other questions? And yeah, Feel free to if you think of something after today, you're welcome to send me an email or to our support desk. But we will be sending out an email tomorrow with a recording of today's session. And yeah, look forward to helping you and assisting you. One last thought: I know that you know, you guys are large organizations, and the payment process can be quite a significant process. If you need any help with giving quotes that you then can get approval for different things, please contact our support desk. They'll be able to give you a quote, for example, for that comparison report that you can get approval for. We also can give you a quote for the program that you can then use to get approvals. And the workshops are generally easy enough. You can book them, but we're also very used to working through the process of registering as a supplier and going through that whole story. So we're very happy doing all of that. And so we look forward to engaging with you, and I hope to see many of you at the workshop on the 23rd of November. And yeah, we're here to help. Great, thanks very much. Lots of very nice positive feedback. Johan, yeah, thanks for asking about my headset. To be honest, I don't know what the brand is. My darling wife actually bought it for me, and it was quite an expensive one. And the microphone is good, so I'm glad that the sound is good and that you're hearing me loud and clear. Pleasure, Bruce. Yeah, pleasure, Jaco. Thank you very much for coming. All right, I think that's it then. Thank you very much for joining us, and yeah, enjoy the rest of your day.